Good morning. Good morning. Just want to record this video, and I want to talk about the new asylum rules, everything you need to know about it. I lost my voice. That's why I don't want to do those live sessions. Yeah, I have a flu, so I lost my voice. And I'm trying to just do this so that I don't have to go to the live session because I'm trying to save my voice. That's my only asset. I guess because I went to Florida, it's hot there. And then when I came back, just got a flu, like the change of weather. But anyway, so let's get right into it. The first thing you have to know about this new rule is that they have to adjudicate the application within 180 days. That's the new rule. When your application goes to USCIS, it has, sorry, to the immigration court, sorry, number one, the application has to be adjudicated within 180 days, meaning it's really going to go fast. Okay. So let's say the person filed a defensive asylum with the immigration court and they never had a work permit before. So what's going to happen is because, we have to wait for 150 days before you apply for the work permit. So meanwhile, when you apply for the work permit has to be pending with USCIS for 30 days prior to getting a decision, which gives you a total of 180 days, right? So this simply means that by the time you basically get your decision, if you don't win, then you're not going to get the work permit. That's just period, right? Because you're not going to get the work permit. Okay. That's just what it says. But we're going to go over each rule and go and see how we're going to interpret that. Hold on, I'm trying to go to the screen. Okay, so yeah, the first thing is on February 3rd, 2025, this is when the new rule got into effect. Okay, the new rule directs immigration judge to complete adjudication of asylum application within 180 days to the maximum extent practicable. So basically, they have to just give you a final decision within 6 months. The memo says that good cause that does not necessarily and in every case constitute exceptional circumstance that justify exceeding the 180-day deadline. So you might have good cause to continue your case, but that's not exceptional circumstances. In other words, in order for the immigration judge to continue your case, you have to be able to establish exceptional circumstances. Okay. That's number one. They have to do it within 180 days to give you your final decision. Then if it's not good, you can appeal. But they have to give it to you in 180 days. If you ask for continuance, you have to show exceptional circumstances. That's number one thing you have to know about the new rule of asylum in immigration court. Number two, what else you have to know about this new rule? Number two, let me go to number two. Number two is that the court will not accept an affirmative asylum application referred by USCIS unless it contains all the supporting documents. Let's say you went to the USCIS, you file your asylum there, basically you started with USCIS. In most cases, that's how people start their application, with USCIS. Then you go, you do your interview, but the case gets referred to court because maybe you didn't meet the requirement over there. The case gets referred to court. So when you go to court and your case is referred to court, the case has to have all supporting documents. The immigration court will not take the application if it's incomplete. Okay? So they reiterate that defensive asylum application need no longer be filed in person during a hearing, and stresses new rule regarding the filing of incomplete applications. So in other words, your application, when you file it with the immigration court, it has to be complete. Okay? And then that's number 2. The application has to be complete. Number 3, there is an emphasis of basically the clock. How does the clock is going to work? The immigration judge can stop the clock only when there are exceptional circumstances. Exceptional circumstances. That's when they can stop the clock. The memo discusses the circumstances under which the clock stops permanently. So when does the clock stops permanently? When the application is untimely filed, so basically incomplete. Not just incomplete, but untimely, basically after the 1 year deadline rule, and then without meeting the exception for the 1 year deadline rule, or maybe when the application is considered abandoned or withdraw, the clock will stop permanently. It means that you're not going to get your work permit until the final decision of the judge. That's it. Okay. The memo pretty much prohibits, okay, the judge cannot ask you whether or not you want expedite hearing for the purpose of the work permit clock. If you want your case to be here faster so that the clock can start over, no, they don't want that. They're not, it's prohibited. They cannot ask you that question. Okay. Again, we're going back to the first rule. It has to be an exceptional circumstances in order for you to continue the case, because the case has to be adjudicated in 180 days, period. You want to continue the case, you have to establish exceptional circumstances. That's high standard, not just good cause. Good cause will be like, oh, I filed for FOIA, I'm waiting for because we usually continue the case based on the fact that if we file for FOIA, waiting for the entire file, then I have to continue my case. That's good cause. They might continue the case under the old policy. But now what they're saying has to be exceptional circumstances, because they will tell you that why you didn't file your FOIA earlier, okay? Now, exceptional circumstances will be like, I am hospitalized, this is proof. I have to go through surgery. I'm not able to physically stand trial and mentally stand trial. This is proof. Then that's exceptional, in my opinion, okay? That's only in those type of circumstances that will continue the case, basically give you another date, okay? But other than that, they have to give you the decision within 180 days in court. That's it. Let's see how it works, right? Because we have clients in court who want to see if we're going to get the case adjudicated in 180 days. Okay. What else? Okay. The regulation specifies that the asylum clock does not run after the judge enter a decision and the application on the application. It does not run while the case is on appeal before the BIA, nor if the case is remanded to BIA. So basically, if you don't, it's in other words, just this is pretty much what I said before, right? Nothing has changed from what I said. If you did not get your work permit prior to the decision of the immigration judge, then you just have to wait for the asylum to be granted. Then you can work. Because when asylum is granted, you can work just with your I-94 uh, new social, because you're gonna go to the social security people so they can give you a new social, unrestricted social. The way you work is with the approval of the asylum, the I-94 that is issued, and your new unrestricted social security. So you don't even need a work permit at that point because you want asylum, you can work in the US. So when it comes to the clock thing, um, you just have to know one thing, okay? Make sure that you get your work permit before, especially if you're applying with USCIS before going to court, make sure you get your work permit prior to uh, the decision of the immigration judge. How do you make sure? It's just like when it's time to apply, apply. Because once the decision comes, it's over, especially when the decision is negative. Okay? So that's pretty much what it says here. What else can I? So it's pretty much so restricted at this point. Okay? That's the conclusion. The judges cannot just continue cases, delay cases that have to decide within 180 days. The only time they can continue or delay a case if the respondent, which is you, the applicant, show that there is exceptional circumstances. This is high standard to prove. In that case, they can delay and continue your case. They cannot accept incomplete application. And once your application is deemed abandoned or after it's filed after the deadline without meeting the 1-year deadline requirements rules, the exceptions are not met, the clock will stop permanently. That's it. Don't forget about work permit at that point. Okay? Pretty much that's what it says. Okay, in conclusion. So this is it. I wanted to just talk about it. Okay, what else? Just give me one moment. I want to see if I missed something else. Yeah, I did. Directing immigration judge to stop the clock only when there are exceptional circumstances. So in general, it's pretty much the same rule, but more restricted in this way. If you apply for asylum, okay, the clock starts to run, right? But then when are you able to apply for work permit? You apply for work permit after 150 days when the application is pending. And then the work permit has to be pending for 30 days before you get the decision. And if the decision gets there, you win asylum, then you don't really need the work permit because you can work because you won asylum. But let's say you don't win asylum. Are you able to apply for the work permit? That's the main question. Well, the decision comes before 180 days. Are you able to apply for work permit? It's going to depend on what? it's going to depend on if the application was incomplete, abandoned, or untimely. If the application is considered abandoned, incomplete, untimely, the clock will stop permanently. Okay? Because the clock, it just stops. Yeah, that's pretty much the conclusion of this. If you have a specific question and you need a consultation with me regarding your pending asylum case, we can schedule it by using the consultation link in the bio. We are going to resume live sessions maybe next week. It's just going to depend on my voice, okay? But I'm going to update on the latest immigration news probably tomorrow or Saturday. I need to gather most news and see. Yeah, I'm trying to save my voice at this point, okay? Until next time, bye-bye.